Hi, it's State Representative Jim Walsh here at the state capitol in Olympia again. What I want to talk with you this time about is about timelines, and how bills that pass through the legislature here in Olympia and are signed by the governor actually take effect as law. We're at the end of July right now, and this year, a group of bills that passed into law in the session that ended in April just took effect as law a couple of days ago. It was over a weekend as the calendar worked this year. And I got some questions from people about why bills that became law were taking effect now instead of when the governor signed the bill some months ago. And that raises an interesting point about the timing of bills becoming law and law taking effect here in Washington. Generally speaking, here in this state, when a bill passes the legislature and is signed into law by the governor, there's a 90-day period in which the law does not yet take effect until the end of the 90-day period. This is part of the reason that when referenda are proposed, they have a relatively short window in which they can become qualified to be voted on at a later general election ballot, because they have to get their signatures and qualify within that 90-day period. There are other reasons for the 90-day waiting period too that have to do with allowing state agencies and courts and other machinery of the state to adjust and prepare for a new law to take effect. Now, there are some situations in which the 90-day implementation window doesn't apply. If a bill includes an emergency clause when it's passed through the legislature, it becomes law and is implemented the moment the governor signs it. There's standard language in a so-called emergency clause that says that the point of public policy in the bill is so urgent and so necessary that it's exceptional and the bill must be implemented as soon as the governor signs it into law. As an example of an emergency clause on a bill, in the recent legislative session here in Olympia, House Bill 1240, the so-called assault weapon ban, included an emergency clause. So it was implemented immediately upon the governor's signature, signing it into law. There was no 90-day waiting period. There was no phase-in. It took effect immediately. Obviously, that was a controversial bill, and the emergency clause on that, if anything, made it more controversial, but that's typical. Emergency clauses are often controversial in and of themselves, and when you add them to a point in policy that's already controversial, you have a lot of controversy. There are other ways that the 90-day window of implementation does not apply also. Sometimes bills will have a specific date in them in which they are implemented. This often applies to tax policy, bills that have to do with tax policy. They will have a date certain, often January 1st of the next calendar year or something like that, at which the new policy is implemented, takes effect. So those are the two ways that the standard 90-day window does not apply, either with an emergency clause that makes the bill implement immediately, or a date certain, usually farther out than 90 days, at which the bill takes effect. And again, the reason for these different timelines is that different sorts of public policy require different amounts of preparation and anticipation on the part of bureaucratic agencies or the general public to abide by them, to prepare for them and implement them and support them in a good order. So this is a constant issue. The 90-day window is standard, but there are other timelines that can apply to bills that we pass here at the Capitol in Olympia. A little bit in the technical weeds here this time, but an important issue and one I've been getting questions about. So timing of implementation of policy, always an issue to ask about when you're thinking about a bill or new law. That's it for this time. I look forward to talking to you again soon.